Good evening. Welcome to the Parent University What Does Dignity for All Look Like in Saratoga presentation. We are here tonight at the McFadden Administration Building to speak about a very important topic, the Dignity for All Students Act. My name is Paul Loy. I'm with Honeywell Law Firm in Albany, New York. We are counsel to the Board of Education, to the school district, and I'm really here this evening to give you some background about the legalities of the Dignity for All Students Act. What is it? How does it apply to school districts? How should school districts go about implementing it? It's my understanding that after I present, there will be a bevy of administrators and faculty members from the district who will be providing their unique perspectives and information about how DASA is being implemented on a day-in, day-out basis at your respective buildings throughout the district. So, without further ado, the Dignity for All Students Act. It is the policy of New York State to afford all students in public schools an environment free of discrimination and harassment. A novel concept, but not necessarily a new concept. The Dignity for All Students Act is a relatively new law. It was created or enacted in July of 2012, so we're now entering its 5th year of existence. It was amended once in July of 2013, simply adding a cyberbullying component. But really for schools, this isn't necessarily new stuff. There were some new obligations, some new requirements, some new documentation, and procedures that had to be implemented. But in the end, it was really all about the basic fundamental premise of making sure that students are in an environment free from discrimination, harassment, and bullying, that they are learning on a day-in, day-out basis about valuable lessons such as respect, civility, and dignity, and how to impart that to one another within the school environment. It does require that schools implement formal policies, procedures, and protocols to handle incidents of bullying, discrimination, and harassment within its buildings. And as I previously stated, it also mandates that school districts start to implement on a regular basis instruction in civility within the coursework. Many teachers have already been doing this for a long time, so that's not necessarily anything new, but this is another formal requirement that school districts are required to undertake under the law. Let me give you a little bit of background about the statute and the genesis of that statute. Around 2010, 2011, there was a series of fairly high-profile bullying incidents that occurred nationwide. The real incident regionally that seemed to really turn the tide with respect to bullying in schools had to do with a Springfield, Massachusetts area school district and a student by the name of Phoebe Prince. Many of you may be familiar with what occurred with Phoebe, but in essence, she was a new student to that particular school district, and ultimately she ended up taking her life. And after she took her life, information came out that she had been involved in a relationship with an older boy, and that she had undergone quite a bit of harassment and bullying at the hands of multiple students in that school district. And naturally, when a tragedy like that occurs, people are looking for answers. And one of the questions that kept coming up over and over was, what did the school district do, if anything, to stop this behavior? What did they know? What did they do in response? How did they go about protecting the student? And it's really from that we now have the Dignity for All Students Act. And from a legal perspective, representing school districts across the state, my clients are, I don't want to say burdened, but they are faced with mandates constantly from the state, from the legislature, with respect to new laws that are being developed. And ultimately, it's up to them to implement all of these mandates. And this was really another mandate that schools had to take on. In the end, though, I think it's obviously it's a very worthwhile cause, but it's a very important mandate in a way. Because what it says to me is this isn't just another hoop or hurdle you have to jump through, but it's almost a way of ensuring that you are doing everything that you're supposed to be doing under the education law to ensure that students are safe from bullying, harassment, discrimination. And if school districts are really following their processes and protocols correctly, following their codes of conduct, following their DASA policies that they've created, in a way it becomes kind of like a checklist of remedies, identifying behaviors, taking action reasonably calculated to end those behaviors, and making sure that students are learning in an environment free from harassment and discrimination. Now we know that this isn't a perfect world, this isn't a utopian environment. Teachers, building principals, administration do the best they can to create that environment, but there's always going to be incidents, there's going to be conflict, there's going to be issues. So long as our schools are following the protocols that they have developed themselves, that goes a long way towards addressing those issues and creating a culture and a climate where students can really feel free to come in and learn, hopefully without the fear of bullying, harassment, and discrimination. So what are you really looking for, what are we looking at when we talk about DASA? What DASA states is that no student shall be subjected to discrimination based on their actual or perceived, and it's not just harassment, it's also bullying or harassment, traits. And the statute goes about and it lists a series of non-exclusive traits that we're looking at. Traits such as race, color, national origin, ethnic group, religion, religious practice, disability, sexual orientation, gender, and sex. Now again, we've had laws in this country and in this state, both federal and state laws, that have protected students from this type of discrimination for years. DASA does go a little bit further than what our federal laws require. Notably, you'll see there's a reference to weight, which was specifically referenced in the statute as a protected trait. But as I said, this isn't an exclusive list. There are other traits or classifications that could potentially become a category. Hair color, skin issues, political affiliations, and one that I think I see more than anything else in working with school districts is bullying on the basis of socioeconomic status. Your wealthier students giving your students who are less affluent a difficult time. So these are types of traits and classifications that school administrators, teachers, staff members, really everyone, every person in the district has a responsibility under DASA, are tasked with reviewing and looking at and ensuring that there's not bullying, discrimination, or harassment occurring on the basis of any of these traits or classifications. You'll note that this only refers to students. It does not refer to employees. It does not refer to parents. While certainly schools develop policies, such as a code of conduct that implements standards with respect to parent behavior, visitor behavior, whether you're on school district property or at a school-sponsored function, DASA itself does not extend to those individuals. So while a student can be the victim of bullying, harassment, or discrimination under DASA, a parent cannot, a teacher cannot, a principal cannot, and so on. Notably, we're looking for the bullying, harassment, or discrimination to occur at the hands of either employees or students. You cannot be bullied under DASA by another student's parent, by a visitor to the district, by students coming in from another school district. The jurisdiction doesn't reach out that way. It's only internally with respect to students and employees bullying, harassing, or discriminating against district students.
I have a question. Can I ask a question, or is that not allowed?
It's perfectly allowed. There's going to be a Q&A time. Would you mind if I go through
I'll wait.
and then?
I'll wait.
Okay, thank you. I want to note, though, that there's also an important consideration here with respect to actual or perceived. Often what occurs in practices, I'll hear about, as I said, I represent a lot of school districts, including Saratoga, and so I get a lot of calls on a weekly basis about these types of issues, and I'll get a question about, a student was being teased for being gay. And I'll say, okay, did you do anything in response to that? Did it seem like something that would fall under DASA? And sometimes what I'll hear is, not necessarily from Saratoga, but from school districts is, well, no, the student isn't gay, so why would we have to address it? It's actual or perceived, okay? So it's not just a matter, it's never a defense to say, well, the student isn't short, or the student isn't poor, or the student doesn't have red hair, or the student isn't Catholic or Muslim or Jewish. Its perception is just as important. One of the requirements of the Dignity for All Students Act is that school districts appoint a Dignity Act coordinator. This individual is appointed by the Board of Education. They are employed by the district. There is generally one in every single school building, and they are trained in the area of human relations. They have to have specific training that they go to receive with respect to matters of patterns of harassment, bullying, and discrimination. And they serve as essentially a conduit or a resource for building principals, district staff, district counseling, and student support personnel, even district administration with respect to these matters. It's my understanding that Saratoga has actually gone a step beyond what is required under the education law, under the Dignity for All Students Act, And not only does each building have a DAC, which is often just the building principal, but there's actually also a district-wide coordinator who assists the building principals with respect to these matters. So we'll talk about a few basic definitions. From a legal perspective, I wasn't here tonight to kind of drill through all the different definitions: gender, race, color, bullying, cyberbullying, harassment, discrimination, etc. But I did want to touch on a few specific definitions for you. Two very important terms obviously have to do with bullying and cyberbullying, occurring within the context of harassment and discrimination. Ultimately, these are issues that we are seeking and that we're looking for. Cyberbullying itself becomes a little bit of an issue because often cyberbullying is not occurring on school district property. It may be occurring through social media platforms, at a student's home, at a mall, at some sort of off-campus site, but districts do have an obligation to be reviewing cyberbullying matters. Okay? We're required to update our codes of conduct to reflect definitions of bullying and cyberbullying, which I know Saratoga Springs has done. What our investigation obligations are, who the staff and DAC are, and how they must be trained, what the training is designed to accomplish, and so on. So harassment and bullying is the creating of a hostile environment by conduct, threats, intimidation, or abuse, including cyberbullying, that unreasonably and substantially interferes with the student's educational performance, opportunities, or benefits, or mental, emotional, or physical well-being, causes or would reasonably cause emotional harm, causes or would reasonably cause physical injury, or to fear for physical safety. I'm sorry for putting this up to my face. I have very small font on the slides. I'm missing a slide. It's really important to take note of the fact that there is a subjective and an objective component to this. In the law, we have a concept that we call the eggshell skull. And what the eggshell skull basically means is that you may have an individual who looks like an NFL linebacker, who's 6'4" and 250 pounds and is the meanest, toughest person you've ever seen. And if that person were to get into a fight with someone and he were to be hit once and he were to crumble to the ground because he has the proverbial glass jaw or something like that, and he is injured, it doesn't matter that you thought that that individual is 6'4", 250, tough, rugged, whatever. They have the proverbial eggshell skull. You essentially have to take a person as you find them. And that occurs with students, of course. You may think a student is outwardly tough, and when I say tough, I mean thick-skinned, seems to be unaffected or unmoved by certain statements or comments, or you just might be hearing or seeing or witnessing behavior that you wouldn't ordinarily think of as being bullying, harassment, or discrimination. If that student, though, perceives that situation as being harassing, bullying, or discrimination towards them, that could potentially be something that would be considered to be a violation of DASA. And at minimum, it's something that as a school district, we would want to address. At the same time, though, there is an objective component to it, a community standards kind of component. And if it is so far afield from what the regular student, the average student in the Saratoga Springs City School District would deem to be bullying or harassment or discriminatory behavior, it may not rise to the level of a violation of the Dignity for All Students Act. So it's a little bit of a counterbalance there between taking the students as you find them, recognizing that different students have different thresholds, but at the same time, when you conduct your investigation, keeping in mind what would be kind of an ordinary response for students in the district. So, as I previously mentioned, I talked about cyberbullying. I talked about how that could potentially be occurring off school district property. We do look into behaviors that are occurring off school property, but we're only looking at them where we think the acts would create a risk of substantial disruption in school. This is a very common standard that's applied. It's actually a constitutional standard to a certain extent. We use it a lot with respect to student discipline. In general, with the exception of cyberbullying, where we have an additional mandate, schools are not out there policing, reviewing, investigating matters that are occurring off school district property, that are occurring outside of school hours. There are occasions, though, where events, incidents can be so significant that there is this foreseeability of a substantial disruption to the school environment. And when that's the case, we do have an we do have a responsibility under DASA to investigate those behaviors, and to respond to those behaviors. And I already mentioned cyberbullying. I think the rationale behind cyberbullying has now become well known. You know, you've heard the talk about once upon a time, a student may go to school, they might get picked on, they might get bullied, but at least then the school day ends, they get to go home, they get to relax, they get to be with their parents, their family, whatever, and they're not subjected to that behavior that they may have been undergoing during the school day. Now, with the advent of social media and the frequency with which students are using social media and the various platforms, Facebook, Snapchat, Instagram, etc., there is a feel and a perception and a reality that the behaviors never stop, and that you are never free, or that you're never able to get away from those behaviors. Someone is constantly, or someone has the ability to put something out there about you that it could potentially be harassing or discriminatory or bullying for the community that doesn't go away, that you're subjected to even when you're home or on your own time. And for that reason, DASA has created an exception with respect to cyberbullying and monitoring cyberbullying even when it's occurring off schools or property. There's a little bit of a caveat, though, with respect to that, and that is, even though we have a responsibility to monitor and respond to it under the Dignity for All Students Act, we don't necessarily have the ability to discipline for those types of behaviors, because our disciplinary standards still relate to behavior that's occurring within the school environment. With there's some limited exceptions that we do apply from time to time that I'm not going to get into, but ultimately we're really looking at the behaviors that are occurring in school. So cyberbullying might trigger a DASA investigation and a response, but it's not necessarily going to trigger any type of disciplinary action against the perpetrating student. In other words, the school would have to use different means of addressing the behavior and remedying that behavior. So, and this is kind of, I think I keep overshooting when I hit my buttons here. This is a really big sticking point between schools and parents and teachers and staff with an understanding of what's occurring. What schools are really looking for under DASA are what we call material incidents of discrimination or harassment or bullying. And once again, I'll have to do this because this font's very small. What a material incident of discrimination or harassment is, it can be a single incident or a series of related incidents where a student is subjected to harassment, bullying, and or discrimination by a student and or employee of the school district on school property or at a school function, creates a hostile environment which is both severe and pervasive, unreasonably and substantially interferes with the student's educational performance, opportunities, or benefits, unreasonably and substantially interferes with the student's mental, emotional, and physical well-being, reasonably causes or would reasonably be expected to cause a student to fear for his or her physical safety. So there are many incidents that occur on a day-in, day-out basis in schools all around the country that are simply disrespectful, uncivil, not nice, inappropriate, that school staff and administration are expected to address. Not every single one of those incidents, though, is going to rise to the level of a DASA violation or a material incident under DASA. These are the standards that we're looking for. You're looking for a pervasiveness. You're looking for the severity of those incidents. You're looking for the interruption and interference with a student's ability to learn. You're looking for a student who feels unsafe now, physically or emotionally. What does the school need to do? You know, foster an environment that encourages student reporting, provide character education to students that should be ingrained in your curriculum, train employees and administrators on how to address and respond to bullying and harassment, follow legally required procedures. In particular, the district has a well-settled DASA policy. It needs to be following its own policy, and be alert and responsive to issues of bullying, harassment, and discrimination that are occurring. This is something that I generally address more with staff members than with parents, but many people are familiar with the term a mandated reporter. Mandated reporter is a term that comes under our social services law. It's individuals that are required by law to report incidents of neglect, abuse, and maltreatment that's occurring by parents towards their children. Under DASA, every district employee is a reporter. It doesn't matter if you are a building principal, the superintendent of schools, or someone who works in a monitoring capacity on a bus or in a cafeteria. Every single person has the same responsibilities. Now, at the same time, if 5 different people witness the same event, we don't necessarily need 5 different people making that report, but the matters need to be reported upon. It's not enough to just be like, I'm the bus driver and I don't have to do that. Or I'm a teaching assistant, I don't have to do that. There's a teacher in the classroom. And your responsibility is basically that you have to report behaviors that you observe or that you learn of verbally within 1 day of viewing or learning of the event. And then you have to follow that up with a written report that's usually directed to the building principal or the Dignity Act coordinator within 2 days after making that verbal report. Excuse me. This is a legal mandate. The standard that's utilized is business days, but for purposes of being able to efficiently and effectively investigate matters, efficiently and effectively remedy matters, it's important that these matters are reported and reviewed as soon as possible. We wouldn't want someone sitting on an incident just because they have a full 2 days to make the report. If you have that time, if you have that availability, go make your reports. An example that I like to give where I understand a little bit of a lag or a delay is if you're a bus driver and an incident occurs on your afternoon run on a Friday, it might not be until Monday, obviously, when you're able to respond or report back to your supervisors or a Dignity Act coordinator that an incident occurred. But it is the district's expectation that come Monday, you are making at minimum a verbal report, if not a written report, of the incident that you observed or the behavior that you learned of. All reports are required to be thoroughly investigated. That doesn't necessarily mean that the outcome every time is going to be that there was a violation of DASA, but at minimum we want a conversation with the individual making the report. We would like someone to touch base with the individual who is the alleged victim and the individual who's the alleged perpetrator. And then investigations branch out from there based upon the information that you're provided by those 3 individuals. An important piece for our school staff is we want to make sure that when you are investigating these matters, when you're meeting with students, that you're reminding them that they should be cooperating with the investigation, but not only that, there's not to be any retaliation. A person that makes a report should not be retaliated against. A victim who comes forward should not be retaliated against, and even a perpetrator shouldn't be retaliated against, because we do kind of live in a world where kids with various levels of maturity or a sense of fairness or a sense of vengeance might try to take matters into their own hand and respond to these matters, and they hear that, Paul Alloy's been picking on my sister, so I'm going to go after Paul Alloy, and I'm going to, get a group of friends to go after him, and now I'm going to make fun of Paul, and we're going to harass him. That's not appropriate. We need our investigators to be reminding the students that the administrators and the faculty are going to take control of the situation, that we're going to conduct a thorough investigation, and that you are not to be the victim of retaliation, nor should you be retaliating against anyone else. And generally, that if you do feel that you're being retaliated against, it's necessary that you immediately report that behavior to an administrator in the building who can then assist you with that problem. So generally, investigation occurs like any other investigation. As I said, we want witnesses to be met with, the victim to be met with, the perpetrator to be met with, in order to get various versions of the events. Ultimately, the person conducting the investigation is going to compile all that information and come to a conclusion. So what do we expect to occur after the investigation? Really what we're looking for is continued monitoring and enforcing of the behaviors of the students. It's important for faculty and staff to stay vigilant, keep an eye on the situation, keep an eye on the students who are at issue, continue monitoring the situation to the extent that stay-away agreements or things of that nature are developed in order to remedy the behavior. Make sure we're implementing those stay-away agreements, make sure we're enforcing the rules of the school. You have a well-settled code of conduct that's very detailed with respect to prohibited behaviors. Make sure that those behaviors are properly being enforced. Make sure that if you have assigned consequences or remedies that you're following through with those. I'll hear about incidents that are occurring on the bus, and ultimately one of the remedies would be to assign seats. And then a week later, we'll hear that the students were at it again, and why? Because no one ever made sure that those students were sitting in their assigned seats. It's a simple thing to do, but follow through with your remedies, make sure that they're being implemented. So here are some ways of addressing the problems, considerations, and actions. The bottom line is that we want to be proactive. We want to do what we can to stop the behaviors as soon as we can. In fact, that's really what our mandate is under DASA, is to take reasonable action that is calculated to address the behavior and to end that behavior that is bullying, harassment, or discrimination immediately. So some things that we look to do is apply progressive discipline. This is something available under your code of conduct. We don't treat a 6-year-old the same way we treat a 16-year-old. We don't treat generally a first-time offender the same way we would treat someone who has had multiple offenses. And we are usually using progressive discipline principles. Maybe the first offense results in an in-school suspension, maybe a second offense results in an extra day of in-school suspension, and so on up the ladder to an out-of-school suspension. But even before then, we're talking about verbal warnings, written warnings, calls to parents, takeaways of privileges, detentions, lots of different progressive disciplinary remedies before we reach those points. Okay? Use of remedial supports and services. Counseling is a big one that we are utilizing. Even in cases where we have unfounded allegations, where we have found that there wasn't a material incident that violated the Dignity for All Students Act, it's never a bad thing to be offering the ear or the attention or the availability of a school counselor, whether that's a school psychologist, a social worker, or even just a guidance counselor who can meet with a student, do check-ins, see how they're adapting, how they're feeling going forward. You want to make these students feel safe and comfortable in their learning environment. Service learning projects, restitution or mediation. I'm hearing more and more that schools are less willing to enter into mediation with their students. I know that there was some training that was going around out there that was concerned about the fact that when in mediation, these students are kind of opening up to one another, that if you have a student that's truly not ready to kind of remedy the situation or to end the negative behaviors, they'll take the information that they learn in these mediation sessions and then kind of use them to put themselves in a position of power or authority over the other student. I do have a little training in mediation from going all the way back to college, and I'd like to think that if the mediation is being done correctly, that shouldn't be the case. I still think it's a valuable tool, but it's something that an administrator would have to consider given the dynamics of the particular students involved. We talk about meeting with parents. Obviously, you want to keep parents informed and abreast of what's occurring with their students. I say this all the time because I'm constantly in meetings with parents. The school district's primary job is to educate your children. The school district's secondary but almost equally important job is to ensure the health, welfare, and safety of all of its students while they're on school property. Essentially, we are in loco parentis to students while students are in our buildings. But at the same time, we want to make sure that parents are partners in all this, that they're aware of the actions and efforts that the school's taking to create a safe learning environment for students, the things that we're doing to address the behaviors that are occurring, and just in general, how their children are doing on a day-in, day-out basis, and how they're responding to incidents that may have occurred in the past. As I said, the action and reaction must be reasonably calculated to end the problematic behavior, prevent, discourage, or recurrence of that behavior, eliminate or address hostile environment, or ensure the safety of the students affected. And really, we try to get there through a combination of various tactics. And what I will hear from time to time from clients is something like, well, this occurred and we had them sign a stay-away contract. Well, that didn't work. What are you going to do now? You always need to be prepared. Your goal is to take that action that's reasonably calculated to end the problematic behavior and prevent the recurrence. But we don't live in a perfect world, and that doesn't always occur. So even though you've come up with a plan, that plan might not work upon first implementation. You might have to move to Plan B, to Plan C, and so on. And it's the school's responsibility to remain vigilant and to keep working on methods of ending that behavior until that behavior has actually ended. We want you to be proactive. We expect our schools to be proactive. We have monitors in various places within the district. When we hear of incidents and situations, we want to make sure that we are responding to those incidents, that we're putting staff in a place where they can supervise problematic behaviors and things that are occurring, generally within your buildings, your high-risk areas, or your cafeterias, your hallways, stairways, locker rooms, arrival and dismissal areas. Basically anywhere where the students are going to be vigilantly watched, outside of the classroom where you have a teacher right there with them. It's good that administrators, teachers at the lower levels, support staff check in with students, see how they're doing, see how they're feeling, because all of this goes towards changing the school climate, making sure that there's clear expectations with respect to appropriate behavior. Honestly, this is the first time I've ever done this presentation for a parent. I'm always doing it for faculty, staff members, administrators, and the one thing that I can't say enough is you are all role models to the students in your buildings. And in a lot of ways nowadays, you're role models to the parents also. You need to be demonstrating and modeling the behavior that's dignified, the civil, the respectful behavior that you want your students to be engaging in. So make sure that you're acting professionally, make sure that you're using appropriate language, make sure that you're responding to things in a measured, positive way. Because the students will pick up on those cues from their role models, and hopefully they will start to emulate and model that